Give me coffee in the morning, gotta have a coffee. Wake me up, shake me up, dip me back on my seat. Pause shit, juice shit, set a feeling so alive. Coffee in the morning, it's the best.
Oh my goodness. I called it the Lori shit show. Welcome back to my shit show. Apparently this morning something's going on, or this afternoon, something happened there. Something happened. Um, can you hear me okay, Forrest? Make sure it's not just on my end here. Thank you for coming back in, by the way. Oh my goodness. Oh goodness. Yeah. So let me know if you can hear me okay. Um, I have the stream pulled up for the trial or hearing. It has not started yet. Yeah. Megan Connor posted a few minutes ago a little live she did during their lunch break that they called it. So I'm not sure if they're back in the courtroom, what all is happening there right now, but we're going to see what we can pull out of all this. Guys, thanks for coming back in with me. I want to watch this hearing, so I appreciate those who wanted to come back in and watch it with us. Um, according to Nate earlier, they were going to show it again on, or have somebody in there, recording this, and it would be on the East Idaho News. But apparently, this local Fox 10 affiliate will be carrying it live here, upcoming at 4 p.m. They say. So, well, they got a countdown going, 11 minutes. I can pull up that screen and we can chill. There were a few other things that we didn't look at earlier. I don't really want to get into something that's like terribly long, you know what I mean, in case this thing starts, but it says we got like 11 minutes. I think we all had enough of Miss Melanie earlier. I don't need to see her for a long, long time. I do have a few things that I wanted to show you guys on the Melanie Pulaski, because that's Lori's niece, and it was her husband Brandon, who's they made an attempt on his life as well, and that's going to be the trial coming up after Charles' trial. So bring you guys. We may do that on tomorrow's show, like a part two, since they're still starting day one jury selection tomorrow. There won't be any cameras there. There's nothing that much there to see or report on. But what we may do tomorrow is finish reviewing some of this stuff that we didn't get to today, with some of the other key people as to that pertains to Charles's trial. Um, we'll hear from Lori's other brother and, like I said, her niece, and a few other things on that as well. So how do you guys think it's going to go in court for Nate today? You think the judge will do the right thing and say, Lori, he's not a witness, let him in? Yeah, thank you, Forrest, for letting me know. We want to make sure we always can be heard. And I don't know what happened with my video there. Some kind of glitchiness went on, and I didn't even know what was happening. So I wonder if jury selection will literally take all week. They got through a pretty good bit today from what Megan, sorry, was explaining earlier. I did hear a little bit of a blurb on a news clip that there was one juror that was let go already because I don't know if it was a man or a woman. They did elaborate that the juror said they were not going to be okay with looking at crime scene photos, so they were dismissed as a juror. I guess that would really bother a lot of people. So it comes with the territory when you're in a trial, though, right? You're going to be seeing things you can't unsee and hearing things you can't unhear, things you don't want to hear and see, but you have to sometimes. Yeah, I think so too, Forrest. I agree, right? She's all like mad at him because he chased her down to Hawaii and has never let her go and it bothered her from day one, right? So she's like, I'm going to take care of you and keep you out of the courtroom. I don't think her tactic will work. Even calling him a potential witness, right? I mean, potentially, what the hell's he got for you, Lori? We all know you're blowing smoke. So it will be and I guess, and like Joe had alluded to, there are still a few motions the judge hasn't decided on. So I'm assuming he will cram those into this hearing today, since it is the last hearing. I know Joe's still busy. I did invite him up. I did send him the link in case he gets a chance to come up. He can come up and join us and talk about the hearing. Megan said she ended up in the wrong courtroom this morning. Remember, Nate was trying to make sure he had the right courtroom because they were going to hold it in the smaller courtroom, the trial, and then they changed their minds. Another judge offered his larger courtroom to accommodate, and Joe brought us that update the other day. So they did move to a larger courtroom, and I guess not everyone knew they were going to be in that larger courtroom to, even for jury selection. So she's like, I made it in there 15 minutes late. So having a hard time there finding. Now they all know where they're going, so that should be a lot easier for them moving forward. Um, it's a little better organized than that shit show over there in Delphi was for people trying to get into the courtroom for sure. You think so, Forrest? Yeah, I don't know. We'll have to ask him if we see him. He's either constructing a tinfoil hat or he's still unpacking and getting all squared away in that place he's rented for the next few weeks to try to get through this trial. Hey, Butterfly, welcome back, hun. Thanks for coming in. We got a countdown going over here on Fox 10 Phoenix News. They're down to 6 minutes and 25 seconds now before they start their programming here for the trial. Or I keep saying trial. I'm like ready for trials. I got trials on the brain. We got 3 coming up. I'm just like, bring them already. Bring them, bring them, bring them. And thanks, Butterfly, for sticking out and with us earlier and putting up with old Melanie. We're done with that girl, right? I've heard of so many interviews. I hadn't heard that interview. Like, I've heard so many with her and watched them, but that was one of the ones I just hadn't really watched, I guess. And then as I was reviewing it, the things that she was talking about, the way they were doing their castings and the certain elements they were talking about really made me pay attention to some of the things that she was saying in that aspect. But yeah, I think we all had enough of that lady. Mm-hmm. I got a snack, and then a few minutes ago, I went ahead and prepped for dinner because when my kiddo gets home, I'm pretty sure he's cooking dinner because it's like he's making his favorite food. So I went ahead and prepped and got all that out of the way for him so he can cook us a good dinner when he gets home. I'm gonna be like, Mom's busy streaming, son. You got this? He usually does. I don't know. He may have some work cut out for him though, because earlier I was outside and I had to move the trash cans, from the curb back to the house after the garbage people came, and I walked past the water spigot, and like I could hear running water. And he's got a bad habit of leaving that thing on, even though we got the sprayer on the hose. So anyway, I checked to make sure that was off, and it's off, and I'm still hearing all this water. So I start moving this thing he has, and moving the siding where I could try to see under the house there, and I see a lot of water and I can hear a lot of water. So I called him and told him. He seems to think it's no big deal, but like, son, you got some major leak going on underneath your house. Yeah, this kiddo's grown and he will cook. But he has a kid of his own, so he has to cook, right? I help. I do a lot of things, but I don't have to cook every night. It is nice. I will not lie. But Mama does have to come in behind him and clean up after he cleans up. You get me? Right, Forrest? You've seen it before, but you pick up on something new each time, right? Um, there's, yeah, a lot of bizarrities, if that's even a word, with Melanie and her things that she says. That's for sure. And I think a lot of us are still beside ourselves as to why that woman was never charged with something. Conspiracy, even at the very least, kind of like Jen Soto and her need for some child neglect charges at the least. At the very damn least. Where's my button to make me bigger? I think my batteries in my mouse are starting to die a slow death. It won't look. I don't want to see y'all's chat. I just wanted that to be bigger. Maybe it'll go bigger when they go live. They're counting down, guys. Now we've got under 2 minutes left. Sorry, I had made myself some fresh coffee. It was like, do I take a nap or do I just get up and start moving around and make coffee? And I think I chose the right decision just to get up, move around, and make some coffee. Otherwise, I may still be asleep, and you guys would have been like, "Where's Salty?" And I'd have woke up going like, "Oh shit." For sure. They've stopped their clock at okay, I thought it stopped for a second. It's still counting down, guys. And I keep hitting refresh to make sure we don't fall behind on there, because sometimes that'll happen if we don't refresh it. We won't be on terribly long this evening because it is, dinner hour and nighttime for all the kiddos. And I don't normally stream at night unless I'm doing something particular, which I don't mind streaming at night. But I know a lot of you guys got things going on. We need to get this last hearing out of the way and see what happens. We'll be here as long as we need to. I know several people were in the courtroom today trying to cover the jury proceedings of today, the 200 potentials or whatever. I think Megan said a lot of their jury questionnaires were returned electronically, so there wasn't a ton in person to show up, as far as that goes. Butterfly, I haven't gotten in the habit of taking afternoon naps. Like after I stream for several hours in the day and all my chores around here are done, I'm like, there's not a lot to do right now. The guys, I call them the guys, my son and grandson, they're not home yet. So I'll lay down on the bed and I'll wake up like about 5 or 6 and they're like, oh, y'all are home? Okay. So I've been doing that a lot lately. But then again, I'm up like really early, like you guys. I wonder if this jury selection will be up by Thursday and they'll actually start opening arguments on like Friday. Because you can usually get through your jury process within a 3 to 4 day period max. 3 days usually is what it takes. Okay, so they are waiting for Fox 10 Phoenix. Let's refresh it one more time. And we're still waiting. That's okay. Right, it's really hard to get back up. Some evenings I do that accidentally. I'm like, yeah, I don't even think I want to get up. I just stay asleep all night. Because once I get good enough sleep, it's rare to stay that way. Okay, looks like they're coming on with something here, guys. Now I can maximize them. And there's no sound on that yet, so it's not us. Uh-oh, why don't we have sound?
Special Projects executive producer George Obi. It is the day we have been waiting for, the Doomsday Murder Trial, Arizona versus Lori Vallow Daybell, accused of conspiring in the murder of her former husband Charles Vallow. And we begin with jury selection. George, we have 52 people in the pool now, and right now there's an actual hearing going on regarding a multitude of motions. Very interesting. We're going to take you there in a little bit, but just your takeaways from the 200 questionnaires. We were sitting in the courtroom, and now we're back here, but Lori Vallow Daybell in civilian clothes, new glasses. She's playing lawyer. It's quite a sight.
It is. These are always interesting because jurors in any case are always difficult to find. In a case such like as high profile as this is, and a high profile defendant, it was interesting to listen to the judge and Lori's defense and the state kind of grow through what they liked and didn't like about jurors. We'll talk a lot about that this afternoon of why a lot of these jurors were taken out of the pool. But again, very interesting because
very important. I mean, this will be the final 16 at some point.
Yes, and I think they felt, at least that I think that you'll agree, the tone that we got from this morning was that they're confident that they can get the 12-6 that they need to start opening statements on Monday.
Even Judge Boreski said we're moving at a good pace. At one point, they had 5 people in a row that stayed in the pool, and they got through the questionnaires, and we have about 50, like I said. But right now, and this is what everybody's here for, we're going to take you that in just a few minutes, a motion hearing. Motions from Lori Vallow Daybell, motions by the state. We're talking about witnesses. We're talking about our friend Nate Eaton of East Idaho News that is trying not to be a witness so he can report on this case, and you guys are going to see that unfold. And spoiler alert, some of you guys have maybe watching us on X and seen some of our posts of what's going on, but we're going to take you there in just a little bit. It is just so interesting to see that Lori Vallow Daybell is not a lawyer. She has this advisory council, and you can see the moments where she's unsure of how she's going to respond. And then you have a prosecution that has years and years of experience. We were literally in the elevator with them, and this is just another day of business, but it's almost like it's harder for them now.
I think there is, there are a lot of landmines that they have to kind of navigate through. Even Judge Boreski, the same thing. I think there are things that he is probably going to come across in this trial that he hasn't experienced yet. But by and large, they are trying to, go through this to a T. They're trying to make sure everything is done properly, so there is no issue. And again, this morning, great litmus test, I think, for at least for Lori and her defense team, because as we know, the jury is going to be very important. So they want to make sure that they do everything correctly and that they bring in the people they want to bring in starting tomorrow for in-person.
And one of the big motions is trying to get 3 witnesses excluded. We just heard some of that. Lori Vallow Daybell calling a lot of the information from these witnesses hearsay, and that they talk amongst each other and show each other their notes in a sense. I mean, this has been going on for 5 years, but one of those witnesses is Kay Woodcock, Charles Vallow's sister, and also the biological grandmother of J.J. Vallow, a victim of Lori Vallow in Idaho. So there's a lot there that's connected. There's a lot of, you can call it bad blood. I think Kay will tell you that. She's been a witness, and this will be her 3rd trial. And she just wants justice for her brother, Charles Vallow. We're going to learn a lot from Charles through the grave, in a sense. I spoke to a former prosecutor on the case, Rachel Smith, the special prosecutor assigned to the first Idaho case, and she said that is the perspective we are going to get. Charles's point of view, what he was going through, trying to get Lori Vallow Daybell help, what she was allegedly saying to him about him being possessed by a dark spirit and a zombie, calling him outside of his name, not her husband, and then this whole life insurance motivation that we're going to learn about. And we know we have 10 witnesses from Chandler Police that are going to be called. I think that we got a good roadmap. I've said it from the Idaho case of what we expect to see from that trial compared to now.
Fascinating when you have this many key players in a case like this who are no longer with us, sadly, and I think that is going to be a challenge. And the judge will have to, make some really hard decisions about what he allows and what he doesn't allow through this trial, what's hearsay and what isn't.
Yeah, and I think it was just so interesting to see, I've watched Lori Vallow Daybell and her expressions and how she engages. She was it seemed like she was excited to see her defense team and that this, was like game day for her. She was dressed in her civilian clothes. We've talked a little bit about the security measures, being that she won't be restrained. She'll have this shock vest or belt that's under her civilian clothes.
Which we didn't see today. We did not see that. She may have had it on, but we didn't see it.
It was hard to tell. Maybe it's a belt. I don't know exactly what it looks like. But she seemed like she was ready to go. But then you also see some moments where she's humbled because the judge is even saying, I can't give you legal advice on this, but you do what you got to do as your own defense. We are going to take you to the beginning of this hearing right now. Everyone who's been watching with us, thank you very much. Let's see what this hearing and how this unfolds.
Finally. Yay.
When I say we want to start at 1:30,
I'll stay muted, guys, and I'll see you guys in chat.
Here waiting for us. I have a number of things we need to go through. Tomorrow morning, we'll continue with the jury selection process. There'll be a number of jurors that report in person to the jury assembly room that will fill out the same questionnaire that we went through this morning. I estimate somewhere between 40 and 60 people doing that. We'll go over those answers beginning at about 10:30 a.m. We'll plan on starting at 10:30 a.m. Whoever's left, as well as the people that we approved to come back from this morning's group, will come here at 1:30 p.m. We'll begin in-person questioning. During the in-person questioning, I'm going to need the full use of the courtroom, including the seats in the back. So those of you that are in the back as spectators might not be able to be in the courtroom tomorrow during the jury selection process. I'm just letting you know. Let's talk about some of these. First of all, for the record, I did get the defendant's notice of objection to the jury questionnaire that was filed on March 20th. The defendant was objecting to, I guess, the phrasing of the allegations that the state has made, and then requested that the fact that she denies the allegation be bolded and underlined it in the questionnaire. I did get your objection. I guess de facto I overruled the objection and the questionnaire went out as proposed. Next I have defendant's motion in limine to preclude expert testimony of Daniel Coons dated March 10th. Let me ask the state, that's Detective Daniel Coons of the Chandler Police Department. Is he going to be testifying as an expert?
Your Honor, we did notice him as an expert in terms of his background in training and testifying as to trajectory. So we did that in abundance of caution, but we did supplement and provide the defense with the background of that. It was provided to the defense more than 30 days before trial. And defense has interviewed him since then.
What was the last part?
The defense has interviewed him since then.
Okay. So, Ms. Daybell, what's the objection?
So for 5 years, of course, he's been on the witness list to be a regular detective, and now he's being put on as an expert. I feel like to give his opinion instead of just stating the facts. So that was my main concern. I don't understand how the trajectory has anything to do with conspiracy, so I object in that way as well.
All right. Has he testified in that regard in the past?
Yes, I believe so, Your Honor. He has been trained in that area and taught in that area. And his relevance, Your Honor, would be because the defense has claimed a self-defense claim as well. It's relevant for that.
Can the state provide me what his opinion is, and does he have a CV?
He does not have a CV. We did actually put the opinion in the supplemental 15.1 that I filed, along with his,
Okay.
I believe, background and training in that as well. So.
I guess let me flesh this out a little bit more. Let me ask the defendant, you've said a couple different things. Are you saying he's not qualified as an expert, or just that the disclosure came in late and you don't think his opinion is relevant?
Well, one, I don't think his opinion is relevant, but also the fact that he's named as a firearms expert. So I don't know if he took a weekend class and that made him a firearms expert. I don't know what his experience was with that. In his CV, it just says firearms expert. So.
Did you ask him those questions? Was it you that interviewed him or your investigator?
My investigator interviewed him.
Do you know if he asked questions regarding his
I'm not
Background,
sure.
training, or expertise?
Okay, so I haven't listened to that yet, so I'm not quite sure. My concern was that he was a regular detective on the witness list for 5 years, and then 30 days before trial, he's now an expert so that he can give his opinion. And I just thought that was my objection.
Well, if that was your basis of the objection on the timeliness of it, the state did comply with the rules as far as notice prior to trial and giving some sort of summary of what his opinion testimony would be. I'll take a look at it. It doesn't sound like we need any sort of Daubert hearing, but I'll take a look at it. So let's table that for now. Next I have defendant's motion to disclose 404B evidence dated March 14 and the state's response dated March 23. I don't know that the evidence that the state is offering to introduce necessarily 404B bad act per se, but let me hear from the defendant. You got her response?
I did.
All right. So what specific bad acts do you think should be precluded? Or were you just asking for disclosure of what they were actually intending on introducing?
I was asking for a disclosure of 404B that they planned on introducing at trial, and what I got was another theory of the case. So I didn't think that any of it was 404B relevant.
Well, I think I agree with you in so much as what was listed in their response, I wouldn't necessarily characterize as 404B evidence. But you have received that, and now you're aware of what they plan on introducing.
Somewhat.
Okay.
Correct.
I don't think I need to make a ruling on that. If there's evidentiary objections, hearsay, foundation, those types of things will be taken up when the state elicits or attempts to elicit that information. I have next defendant's motion to exclude state witnesses dated March 14 of 2025 and the state's response, specifically defendants requesting to exclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. The state filed a response on why let me just make sure I'm looking at the right one. The state's going to offer some sort of testimony from these three witnesses that are going to talk about, it'd go toward the element of premeditation and or motive. So what is your objection specifically?
Mine, Your Honor?
Yes.
Oh, my objection was that after their interviews, after their defense interviews, that it came to light that their information came, well, one specifically came from Dateline, and then they called each other and their information came from each other. So
I guess I'm working a little bit in the dark. What information is that?
whatever they're, I don't know, planning on testifying about. None of them have personal knowledge of any kind of crime, so.
The state's not saying they have personal knowledge of a crime. They have personal knowledge of things that may lead a jury to infer some sort of premeditation or motive. So what information is that? Let me ask the state. Or what's your offer of proof on why they're relevant?
With regards to Christina Atwood. She is a person who was present when the defendant was speaking about the victim being possessed, which goes to, again, the motive of this as well as the premeditation, and those statements were made months in advance of the actual murder. With regards to Nancy...
So that's going to be offered as some form of admission from the defendant.
So that would be admission by party opponent, and that's personal knowledge.
Did you say that was Nancy Jo Hancock?
Oh, that was Christina Atwood.
Christina Atwood.
Nancy Jo Hancock is the last person that saw the victim alive prior to that. What she knew about this was hearsay, but her statements to the victim of what he should do were her understanding and expression to the victim that he should tell the defendant that he had changed the life insurance policy to stop all of this from going on. So she both sees him the night before, is aware that he's there, and then she makes statements to him regarding what he should do.
Okay, and then...
Kay Woodcock is the person who actually obtained the life insurance policy, which the state is alleging is part of the motive. And she also has information relating to the victim himself. There are allegations, again, of the self-defense, the use of a baseball bat, so she can provide background on the victim in that area as well.
All right. Do you want to have further argument?
Just the fact that this information that is supposed to be coming forward is not... All these witnesses are getting together and talking about all this and comparing all their notes and all these things beforehand, and then they're telling us that in these interviews. Well, I talked to her 100 times. Well, I talked to her every day. Well, she told me this. Well, she told me that. So their information is not firsthand. These witnesses are all coming together. They're all watching everything that goes on TV regarding this, and I would like them all precluded.
Okay, well, you're always allowed to cross-examine a witness about any biases they may have about those things that you've just talked about, colluding with other witnesses. Those are all areas of ripe for cross-examination, but they're not bases to preclude a witness. The court finds that, based on the state's avowal, that those three specific witnesses do have some minimal, although very limited, relevant information to provide and could be helpful to the jury in understanding the case. So the court will deny the motion to exclude the state's witnesses. Again, this ruling doesn't preclude you from any objections you may have to if they're testifying to hearsay or something like that. Next I have, is there a Mr. Eaton here appearing?
Your Honor, Matthew Kelly, I represent Mr. Eaton.
Okay, you filed a motion over the weekend. Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho, and based on the filings, believes he doesn't have any relevant information and shouldn't be listed as a witness. So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But there's several things off the top of my head that is relevant. Right now, one of the things is it's different now, right? Because he's had this off-the-record conversation with the prosecutor, and he's kind of made himself a witness. He's kind of made her a witness.
How so?
In the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back up. How is he a witness to this trial? How does he have relevant information? Relevant information means a witness has testimony that makes some fact in the case more or less likely. So how does he have relevant information for what this case is about?
Okay, so initially when I put him on my witness list, my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial, in calling him. I found it funny when I read the beginning of this. He says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
All right. Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
I've been watching most of the interviews and I take my own notes, so yes.
Go ahead.
Your Honor, two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness, the party calling him would have to comply with ARS 12-2214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements, but I would suggest that if she wants to call him as a witness, she would absolutely have to follow the requirements of the subpoena law, and we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
All right. I'm just thinking through this problem. If a witness got on the witness stand and said something different in testimony than you saw on an interview with Mr. Eaton, you would then play that interview. You wouldn't even need Mr. Eaton to do the impeachment because you could impeach them with the interview by playing it for them in court or something like that. So now that I'm kind of thinking it through a little more, I'm not sure.
And I wouldn't need him to lay that foundation for the interview?
I'm really trying not to give you any legal advice because you are acting as your own attorney, but if the witness admits that's them on the interview and that's their statement, that is foundation. So
He's interviewed law enforcement, almost all the law enforcement that's going to be, up here on the stand. So it's not just witnesses, it's law enforcement.
well, when I say witness, I mean generally any witness, regardless of their occupation. So I don't foresee, I see it in only the narrowest of situations where he could even be called to as a extrinsic person to testify about the impeachment. You'd have to jump through a number of hoops before that as far as presenting the witness what the statement is, and depending on whether they admit or deny that it's them on that video or interview or whatever the case may be that you're referring to. But I'm inclined to strike him as a witness at this time, allow him to be present if he so chooses in the trial. But then again, if you wanted him as a witness, you would need to subpoena him. But at this point, I'm going to strike him from the witness list and permit him to be in the courtroom. If there's a situation where you think something has happened during the trial where you think he should be called as a witness, I guess we'll cross that bridge when and if it comes. Okay?
We could just call him up from the back?
Well, we'll address it when and if it comes, yeah.
And Your Honor, I would ask that if that were to occur, that I would be notified and given a chance to appear and be heard.
Well, everyone will get a chance to be heard if we cross that bridge. I just don't see us crossing that bridge, but I could be wrong. So at this time, it's sort of striking Nate Eaton from the witness list. He can be present if he so chooses in the courtroom.
Thank you, Your Honor.
All right, thank you. Let's go next to the state's motion to preclude media from displaying or disclosing phone numbers and email for witnesses and victims. I guess I have no problem granting this in concept, but let me ask the state, are these people are going to testify, this is my phone number or this is my email, or it's going to be displayed up as part of the evidence on the screen, or both?
Your Honor, it would be both. Some people would have to testify as to their phone numbers or emails that would also then to establish the foundation of then conversations that are on text messages, emails, iCloud accounts. So my concern obviously is there are both victims whose information could be displayed up there, and I think the Constitution allows them to request that that not be displayed. But additionally, just for safety concerns, given the high profile nature of this, for witnesses who have, several of them have attempted to not be part of the media and have not given interviews and would not want their information to be out there, given that this is being live streamed, having their phone numbers or email addresses live streamed out there to the world, I would ask that that not be done.
All right. Does the defense want to be heard on any of that?
No, we agree.
So we're not actually being live streamed, but there's a 30-minute delay order on broadcasting what's in the courtroom. I already have a protective order that jurors can't be broadcast in any way. And I have an order that the feed can't broadcast sidebars that we might have. So I'm going to order that the feed also, to the extent you can see it visually on an exhibit or something, they shouldn't film someone's phone number or email. And then, I don't know if the right person's here. Do we have the ability to, does the media have the ability to bleep out or silence if someone says my phone number is 480 blah, blah, blah? we'll find that out before we start the trial. But
Thank you, Your Honor.
that'll be the order. As for anyone that's doing print or podcasts or anything like that, you're prohibited from reciting an entire phone number or an entire email. You can use the area code, or you can use a couple digits at whatever, at live.com, at outlook.com, but I don't want their emails broadcast or reprinted. Let's go to state's motion to preclude Lonnie Dorkin and preclude noticed witnesses. Did Mr. Dorkin ever get a report prepared?
Not that the state has received.
Do you know?
So, okay. Your Honor, most likely, we're having an affidavit sent over from Mr. Dworkin tonight. He has found a discrepancy in the information that he downloaded and the information that was turned over initially by the state, and he wants to explain what that is and how that will be relevant. So if we get it tonight, we'll forward it immediately to the state, of course, tonight. He was working on a bunch of cases, and he's doing the best he could to include our case and get it done as quickly as possible, as when he was assigned from OPDS.
Well, at this time, I'm inclined to preclude Mr. Dworkin, granted something pretty extraordinary happening. I offered you a continuance last time we were in court in order for you to explore that possibility. You declined the continuance. So it's any disclosures late at this point. I'm not going to slam the door on it completely, because he may or may not have anything that actually ends up being useful. But at this, if depending on what he actually has, we can talk about it. But at this time, he's likely to be precluded as a witness, because the state wouldn't even have an opportunity to have their own witness or rebuttal witness look at something prior to trial. But again, depending on what you have, we can talk about it again.
Okay.
The rest of your witnesses, we've already talked about Nate Eaton. I don't know if we need to go through each and every witness, but I think where I need to start is if a witness hasn't been served with a subpoena to appear in court, there's no requirement for them to show up for your trial. If they have been served, they would need to submit to an interview with the state in advance of their testimony. And then the third aspect is they need to have something relevant to testify about, which relevant, I told you a little bit ago, means they have a testimony that's not based on hearsay, that tends to make either a fact more likely or not. So Why don't we go through, I'm trying to compare your witness list to the state's motion. Let me see here. So Nate Eaton, as of now, is not a witness. Next, we have, I don't know how to pronounce her name. Is it Viasia?
Vicia.
Vicia.
East Idaho.
Is this one of the ones the state was able to get a hold of?
No, Your Honor, we did call the numbers and left voicemail. I've not had any response, and it's my understanding that when I interviewed the defendant's investigator, Jeff White, he also was unable to speak with her.
All right. What about Gabriel Bonilla?
Your Honor, I had an update on that one in the.
Guys, I'm just going to pause real quick because Joe doesn't have a lot of time. Welcome, Joe. We were like going to send out the bat signal.
Thank you. I've been busy.
So what I figured you were. I told the guys earlier that you were busy today, and I told them I dropped you the link earlier just in case you got a chance to pop in. So you saw, though, have you been listening to the hearing?
I have while I've been working, and I think I heard him say there may not be any seats for the public tomorrow or for jury voir dire.
Yeah. Voir dire. Yeah, I asked in the chat. I knew you weren't in here yet, but I was like, did you hear that, Joe Schmo? Then I was like searching for Joe Schmo.
Yeah,
But
that's what I heard.
Yeah, something about it may be so full tomorrow with the jurors that they're going to need those seats. So
Well, and it sounds like there's a process to get back in after lunch break too. Like they clear the courtroom, and then there's a process to get back in. You have to be approved to get back in.
oh wow, like
Just
Delphi
like
shit?
Delphi, yes.
Oh my God,
Delphi all over again. Ugh.
Dude, I was hoping you wouldn't have to go through all that again. Make sure you take snacks and stuff. I know how you get when the lunch breaks. You don't like to leave. You like to stick around.
Yep.
Okay. So for those just joining, we are finishing up. We're going to watch the rest of this hearing. Who was it specifically asked about Nate? Yes, so they've already went over the Nate Eaton stuff, Rachel. And Nate is allowed in. The judge struck him as a possible witness for Lori. She explained why she thought he was a witness, and the judge was like, nah. And I called it. You can just go back and watch the interviews he's done with said people if you think they're up there lying about their testimony. And the judge agreed. He agreed with me. And he made that call. So, but again, thanks for coming up, Joe. If you can stick around, we'd appreciate it. If you have to go, we completely understand.
Yep, I got to go. I got to get this thing wrapped up, so I'm all ready to go early tomorrow morning. That's my plan.
So you're going to try to go ahead and go down there and try to get in anyway?
Yep.
All right, well, we'll be waiting for your updates.
Not any 3:30 in the freaking morning, though.
Yeah, at least you don't have to do all that. That's for sure. Yeah,
and it's going to be warmer. It's going to be warmer than Delphi was.
That's for sure. You have no freezing cold 3 a.m. lines, right, to have to set up in. Spencer says, I'm a local. We should organize line sitters. Show everyone all the love Arizona has to offer. Nice. Look at that, Joe.
Oh, wow.
So, yeah. Well, we appreciate you coming in, and I'm going to go live. There's some more stuff I wanted to present to the community about some of the players in the case here, and we didn't get to all of that today. So I'll come back in the morning and do some of that as well. So if you're able to give us some updates from the courtroom as through text or whatever, I'll let the people know as you come in. And then when you get your breaks, are you going to try to go live during lunch break tomorrow or anything like that?
It depends on the situation. It depends.
No direct plans yet, guys. He's going to play it by ear, and we're here for it.
Exactly.
Butterfly says, be safe, Joe. All right. Well, again, thank you for coming in. We appreciate it, and we'll get back to the hearing now. And it's not much left of it anyway.
Have a great day, everybody.
Thanks, Joe.
Sense that on Saturday, so when the state interviewed, again, Jeff White, the defendant's investigator, he had not been able to speak with Mr. Bonilla. I also called and left a message on the phone number that I received from the investigator. On Saturday, the attorney for Mr. Bonilla called me, and Matthew Ballard, who represents the Church of Latter-day Saints. He advised me that Mr. Bonilla has not been served with a subpoena, but I did not speak with Mr. Bonilla or was not given an option to speak with him.
So we don't know if that person's been served or if they have relevant information.
According to the attorney, Matthew Ballard, he has not been served.
All right. What about, well, why don't I just ask the state? I've got your supplemental and your other one. I know you've actually talked to a few of these people on the phone.
Correct.
Is there anyone on this list, and I'm looking at the defendant's supplemental 15.2 filed March 12, on page 2, there's a number of witnesses listed out. Is there any on this list that you have talked to that you don't object to being called?
Your Honor, I think that there is potentially minimal relevance from Summer Shiflett.
Shizlet?
I think that's a misspelling of her sister's name.
Okay.
We were laughing about that earlier today, remember? It's Shiflet, and that is Lori's sister, Summer. Yeah, right, Rachel? Did you caught that too? Very interesting, right? But he hasn't been served a subpoena yet, so what's up with that, right? I want to hear from this guy.
I think there's potentially minimal relevance for Janice Cox, her mother.
Okay.
Adam Cox is actually on the state's witness list, so we don't object to him.
The state is calling Lori's big brother Adam. He doesn't care for his little sister at all. That's interesting too. Like I said, guys, he's got a podcast, and there's a lot of things he says in that. I have to get the name of it. I have to go find it.
I did speak with Zachary Cox. I'm not aware of any relevance as to this case from him, but I did speak with him.
I see in your pleading that he advised you he's not been subpoenaed.
Correct. Everyone I've spoken with has not been subpoenaed.
All right.
Your Honor, our subpoenas are with OPDS right now, and they should be being issued currently. The state talks about in their response, like, the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years since this case started? They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not gonna let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't.
Scream it. Preach it so everybody can hear it. Those in the back, those that pretend they can't hear. Same thing in Idaho. We had to waive our right to a speedy trial to be effective. Bullshit.
don't not want to give notice to the other side with the limitations at the incarcerated state where I am and the limitations with OPDS of getting Lonnie Dworkin late in the game that they did. I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say...
And I shouldn't be able to represent myself because of that fact? That negates my constitutional right?
I didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks, that makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother, Alex Cox, and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
So what I'm struggling with is you just saying that it's relevant doesn't actually make it relevant. It may be relevant. I'm trying to find out the relevancy. What you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right, Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
How is her daddy being an insurance salesman going to help her when it comes to that phone call she made to the insurance agency, right? My husband's gone. I want his $1 million and I want it now. Oh, my daddy told me to make that phone call. Lady, you're a grown woman. We all know to make that phone call if our loved one passes and they have a life insurance policy. It ain't pretty, but we all have to go through it, Miss Lori. Go on and let her daddy come in there, judge, and talk about it. I don't have no problem with her daddy coming in there because I think from what we hear, he's a weirdo too. We need to see his weirdoness.
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper and I need to make sure witnesses have relevant information. And just like you have the right to interview all of the state's witnesses excluding.
Y'all, it's probably a good thing that trial is going to be a 30-minute delay because I plan to cover that damn thing and I don't know if I can refrain from stopping and talking and throwing shade. I'll do my best, but I don't know if I can.
Victims' rights, people that can deny having an interview, they have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
they also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this other than maybe we should take it up as we progress through the case, but
Your Honor,
some of these people may or may not be even served.
Yeah, my concern is obviously I have attempted to reach these people. I've made my good faith effort. I've been told both by myself in attempting to contact them as well as the defense investigator that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point, then the state can try to at that point preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them, I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information because they're not going to be here and they're not going to testify.
Oh, hell.
So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. Even if they submit to interviews, I may have to make a determination whether their testimony's relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest of these, I think we're going to have to take up maybe on a piecemeal basis, but I don't want it. It's not going to be a situation where,
You know, who are all these people and why can't they be found? Are they hiding? How can you not find them? Are they missing in America? Should we all be looking for them, throwing out their pictures and flyers? Good Lord. What do you mean? Welcome back in, Sinead. Welcome in, everybody. Thanks for coming back in and joining us. This little hearing is almost up, it looks like.
you're ready to call them in as a witness the morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually going to be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that, and I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them, but I'm going through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So we are doing the best that we can.
Okay. All right. We next have defendant's motion to dismiss for violation of confidential communication and the Sixth Amendment dated March 18 of 2025 and the state's response. Let me ask the defendant first if you've received the state's response.
I did.
Did you say you did or didn't?
I did.
Okay.
Yes.
If you have an attorney in Idaho that is working on an appeal, it appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line. And really that's about it. So how does this arise to some sort of nefarious interception of things? Because it was put on a public chat system that the jail uses. You know it's not confidential, and you're told it's not confidential. And then even if I look at the substance of the messages, there's really nothing in the messages that would arise to some sort of confidential communication, just trying to set up a meeting and get the unrecorded legal line set up.
Who's saying that they're not confidential?
Well, the
Who's
jail.
telling me that they're not confidential?
Your own attorney, it looks like. here's a message. I see that they came and got you. I'm working on getting a confidential attorney line set up. The implication being that this message is not confidential. The next one, again, just checking in. Hope things are getting a little better for you. I'm still working on getting a legal line set up. The implication is that these are not confidential.
Okay, so then he received a letter from MCSO that said, your phone number is now confidential and arranged for confidential client privilege communications. So
Phone calls.
From my no, it says this phone number is connected to that.
Oh, she told him, no, you're wrong, Judge. Because I'm paying attention. This involves when she was still incarcerated over there in Idaho before she was extradited, while they were trying to work out the logistics, and she was trying to talk with her attorneys, the original attorney or whatever from the Arizona case is what they're discussing. But she's going to be super combative, it looks like, during trial, don't it? We all better get big ass buckets of popcorn.
So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. So all the communications after the date of the exhibit that we put in our motion, when he got that letter from MCSO that now all of your things will be confidential. Okay. Now they will be confidential. So my understanding, and I'm the only one that can waive that privilege, right?
And I think after that, when his line was approved, there were no other disclosures of messages between you and him, correct?
No, there are.
You received other disclosures of intercepting messages between you and him?
So those go up to the 24th of January?
No, the only thing I saw was up to, I think, late December of 23.
Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not. So the prosecutor who obtained these, her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review if she's subjecting herself to client privileged communications, instead of reading them and finding out and assessing for herself if there are anything in there that's confidential information between me and my appeals attorney. I have no other way to communicate with him when I'm in this incarcerated situation because I was brought here to Arizona to deal with these charges. So it is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion, and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
Well, you reminded me that when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client attorney privilege.
Well, not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone number or I call that phone number.
Correct.
So,
if you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
but I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that.
That's not true.
I assumed he was just getting them on his same phone that we were having client attorney privileged communications. And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them from MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see anything that warrants them getting them from MCSO in the first place.
All right, let me hear from the state.
Your Honor, I think that the state's motion really covers the law under this. The defendant and her attorney were provided with information, whether or not she understood it or not. Her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means to communicate. In this case, the state, obviously, I disclose those before I even look at them. I understand that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the defendant because I don't have the option of not providing them to her since they have been obtained. I think if you apply the case law in this, the defendant cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call and to speak.
Are the three, I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say that tablet messages between Ms. Daybell and Mr. Jerem do not end on December 28th. They continue.
And there is privilege information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because the context of the messages say, I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this
before.
is not confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number now has.
Okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
How is he using it incorrectly?
I just told you. He's not messaging through the phone number.
Lord, this judge is going to need a good stiff drink at the end of every day of this trial. Maybe we should start a fund for him some liquor. If he's not a drinker, he will be when it's over.
He's using different IP
How
addresses.
can you message other than the phone number? I don't understand that.
I don't understand that either, but if it was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from? They're given to you by the state?
They're right there listed on the messages.
I'm just saying, where are they obtaining those from?
From your attorney's messages.
Well, her appellate attorney from Idaho should have explained all of that to her. And Miss Thing, there's been no movement in your appeals case. I got the whole case file. It's still right there on the Idaho page. Thank God they changed it up, so when I'm scrolling down through Kerberger, I don't run into you by accident no more. I just got to go straight to her and click. But I do keep an eye on her appellate process over there in Idaho, and there hasn't been anything filed in a very long time. I don't know what the hell she's even over here having a meltdown about.
From MCSO?
Yeah.
Unless she said some very interesting things to that appellate attorney, right? That she doesn't want revealed. We'll see.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so. It says Craig Durham, and then under it is the IP address from the device that's being used.
Okay, and then Ms. K is reading all of these messages and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So he's not messaging with the phone number.
I've told you 5 different times now, lady, and she can't even get past this one issue. We may have some long days during that live stream of her trial. Now I'm gonna call the trial hearings. I'm so backwards right now. Goodness.
He's messaging from different IP addresses.
Okay, can I ask if these messages are being disseminated anywhere to Idaho, to the prosecutors in Idaho? Because that's definitely affecting my appeal if that's the case.
Yeah, so Brightwell, I think they're talking about because they're given the iPads, they issue them in the prisons. And so she was making the communication through the iPad. So therefore the IP address would pop up. So that's what they've been talking about. If I'm not mistaken, that's where all the communication was coming through, was her tablet. And those things are monitored by the police, by the jail, right? And the prisons. Because they've been using this stuff in prisons for a long time now. Like you can email your family and all that sort of thing.
I don't know.
Have not been sent to anyone other than the defendant, Your Honor.
All right. So there was some communications I find that were intercepted between Ms. Daybell and her attorney. The state's not to use those communications. They're not to disseminate those communications, but I do find that they weren't purposely sought out by the state.
She got her a little bit of a win there.
And that dismissal isn't the appropriate sanction if there is an appropriate sanction.
Mm-hmm.
It's order denying the motion to dismiss for violation of confidential communication.
Yes. So she wanted her whole ass case dismissed because of that. Lord, better attorneys than you have tried to get cases dismissed and they were not successful. You got to have something better than that, Lori.
All right, then we have defendant's motion to dismiss for prosecutorial misconduct dated March 21st.
Oh, Lord, here we go with that. So, Sinead, what they were talking about with the appeal and everything, that's the communications they were just talking about was between Lori and her appellate attorney over in Idaho, where she is appealing her death sentence that she received over there for the murder of her children. So she's appealing that case. So there is communication. That's what they're talking about between her and that appellate attorney out of Idaho.
And the state's response. The motion to dismiss for prosecutorial misconduct was filed on March 21. The response, I don't see a date on the response, but I do have the response. Did you get that response? Ms. Daybell, did you get that response?
I did, Your Honor.
All right.
It's like she just speaks out of turn, blah, 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 blah. And then when he asked her an exact question, that's not the first time she sat there in silence. And he's had to ask her again. Like, you don't got no problem talking a minute ago, Lori.
So your prior attorneys had actually, let me back up. The state filed a motion back in, I think it was September of 2024, asking the court to preclude your defense team at the time from making public records requests through Gilbert and/or Chandler police departments. I denied the state's request, saying that the defense is free to do their investigation and make public records requests through appropriate means. So that's part of your complaint, that they didn't provide those public documents to the defense. That's sort of a civil issue, I guess, but let me hear your argument on that.
That isn't really the complaint itself.
That's your first paragraph.
I know, but the complaint is that
I'd like to take each allegation and deal with them one at a time.
I understand
that's
that.
your first
My
allegation.
complaint is the interference by the state, Ms. Kay in particular, in stopping that and interfering with us trying to investigate and do our own investigation. It is a violation of the constitutional right and due process. And she did do it, and she did do it purposefully. And then after she did it, and we weren't allowed to have anything from either of the police departments, then she filed her motion. And then later, the day that I was Rule 11, that is the day after when you said that you denied that motion. So I don't know what she did or what she said to Chandler and Gilbert to stop them from giving us any information. But as soon as we put in a request, we were cut off. No information. You can't have anything. That's when I was trying to, the big video that we're trying to get in Gilbert, that's what I was trying to request. I tried to request that myself because I would have my investigator go and explain what that was and why we didn't have it. And so we were precluded from doing all those things by the state. They should not be interfering with that. That's one of the reasons why everything has taken so long. We haven't been given things we've asked the state for. We haven't been given them. We tried to get them from Chandler and Gilbert. We can't get them from them. She's stopping us from getting from them. How are you supposed to put together a defense?
So when your prior defense counsel put in that request back in September, the state says that they obtained those information and gave it to your attorneys on October 1. So why are we waiting until March to address this if you had an issue with that?
I have had an issue with it the whole time.
But why didn't you file why didn't someone file a motion back in after, December, November, January, February, saying they had an issue with this?
I did. These are in my motions to you for specific discovery. I discussed this exact problem.
Okay. Well, now you're saying it arises to prosecutorial misconduct.
It is.
Right. This is the first I've been made aware of that, as far as I know, that the police department never honored the public records request. If they don't honor a public records request, there's a process to go through regarding that.
Which is what?
I'm not going to give you legal advice. All right. Your second allegation, the prosecutorial misconduct, we've already kind of dealt with, that she distributed the state distributed attorney-client privileged communication. We've discussed that. The next one is legal advice to defense witness Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court. So how is that improper?
It's taking her word for that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only two parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there, and we don't know who's saying it, and you're just taking her word for it, like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court, and I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Ms. K, okay? Just because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom? I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing. Even if she had said you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation, is that correct?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do we know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can
interviews
interview him.
recorded?
You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness, okay?
Not a witness anymore because you just precluded him.
All right. You can interview him. You can have your investigator interview him.
So even though he's not a noticed witness now, we can still interview him and try to find this information because we can't get it now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Of course.
All right, 609 motion. The state's alleged a total of 7 felony convictions in the state of Idaho. Under Rule 609, the court finds that limiting the number of convictions and the nature of the convictions to be appropriate as to not be overly prejudicial. There is an interest in allowing a jury to know that the defendant's been convicted of at least 1 felony. But let me hear, I'm inclined to probably limit it to 2 felonies in order that they be sanitized. Does the state want to be heard on that?
Your Honor, I do believe that the court should allow for at least 3. There are multiple dates and multiple victims in those and multiple different distinct incidents. And I believe that it would be appropriate to, when we're talking about the credibility of the defendant, to allowing in 3 of those.
I looked at the date ranges and I looked at the actual counts, and some of the counts, obviously the laws are titled differently in Idaho, but there's a couple of counts that specifically have what I would call dishonesty built into the name of the conviction, the first-degree murder and grand theft by deception. Those are counts 1 and 3, specifically. And again, these only become relevant if the defendant chooses to testify. I did read the defendant's response asking that all of them be precluded. Let me hear from the defendant.
1 second, Your Honor. Your Honor, I haven't had a time to, I wasn't planning on talking about the 609 today, so I'll just refer to my reply.
Well, we can table it till later in the trial because, again, it doesn't become relevant unless you choose to testify, but you know my inclination and what the state's argument is.
Okay.
This morning I handed each side proposed preliminary instructions. We don't need to discuss those now, but depending on tomorrow how far we get in the jury selection process, maybe you can be prepared to tell me if you object to any or if there are additions or corrections that need to be made. All right, I think that's going to be it for today, but let me check with the state. Is there anything else we need to address today?
I think just for the record, Your Honor, in terms of allowing in witnesses the gallery, I think that you had indicated you would reserve 1 row for the next of kin.
Yeah, let's discuss that. We're going to put up signage after we complete jury selection. So the first row on both sides behind defense counsel and behind the state will be reserved for immediate family members, next of kin, those sorts of people, relatives. The very last row on both sides will be reserved for media. And then the middle rows in between those two will be kind of a first come, first serve general public viewing area.
That's you, Joe.
Any questions about that?
I do just want to make sure that, assuming we are leaving on the defendant's mother, father, sister,
Well, if they're potential witnesses, they won't be in here.
the state will be invoking the rule of exclusion.
Do you understand that, Ms. Daybell?
I do.
All right. So as long as people that we haven't already addressed other than Mr. Eaton remain on the witness list, the rule of exclusion would be, in fact, it means that they won't be allowed in the courtroom except for your investigator can be in the courtroom. And they're precluded from talking to anyone about their testimony or other testimony until they're released as witnesses. Anything else from the state for today?
I don't believe so, Your Honor.
All right. Anything from the defense for today?
A couple of things, Your Honor. We need to discuss the,
Of course.
How the division would like the media exhibits.
What?
How the division would like the media exhibits, if we're presenting recordings or audio, individual flash drives for each exhibit. There wasn't.
Depends on how you're going to present them, but I would say, yeah, probably 1 flash drive per recording or exhibit.
And then I'm guessing 3 copies, 1 for state, 1 for.
I don't know that you need copies if you've already disclosed it to them. Just tell them what it is when we're marking it and tell the clerk what it is with the description so it's clear on the exhibit list
The usual
which
lady.
exhibit is what.
one more thing, Your Honor. I wanted a clarification. In your minute entry dated the 25th regarding the defendant's motion to remove restraints. So my understanding when I read when I read what was from MCSO, and then you put in here, however, at the sheriff's discretion, one or more armed sheriff deputies may be positioned near the exits. So what their recommendation was the minimum amount of restraints, meaning if there was going to be an armed guard, then they would not have to do the belt. So I was confused by and wanted a clarification on what you were actually ordering, because the DOs had a question about it with me this morning, so.
I ordered that you don't have to wear the leg restraint, but that you do have to wear the rack belt, because that is not going to be visible to the jury. The leg restraint's a little more cumbersome and visible, and since you're representing yourself and you're going to need to approach the podium and those sorts of things, I ordered the removal of the leg restraint. You will wear the rack belt. Office, if they want to, they can position a couple deputies in the back if they want additional deputies.
Well, their recommendation was that you wouldn't have to use the belt at all if they had the armed guard.
I read their response.
Does she understand what a recommendation is and that he's the actual judge?
And their recommendation, and that's my order.
So what is it exactly?
That you have to wear the rack belt, but not the leg restraint.
And that they will or will not have armed guard?
It's up to them.
Okay.
All right, so tomorrow we're going to start at 10:30 with going through the answers on the questionnaires that the walk-in jurors will fill out in the morning. And then in the afternoon, we'll have in-person voir dire of those potential jurors. The court's going to seal the FTR tomorrow for the portion of the in-person answers of the jurors, which should be from 1:30 on. All right, we'll be at recess.
All righty. I think that judge was getting a little tired, don't you guys? You could see the look on his face and the, how many times I got to explain it to you, ma'am? He's going to have a hard time with her in court. She's going to be objection, objection all the time to herself. Yeah, bring in the belt she's got to wear to stun her ass, and bring in the guards, right? It's like the judge had to tell her 3 or 4 times what his actual order was. I can't believe that. If you're already having explained the stuff to her a couple of times during a hearing, can you imagine how it's going to go during trial? Wow. Yes, pretty much. Yeah, she did. She lost all of her emotions. I guess Nate Eaton is in, but like the judge just said, call him. I'm going to be curious to see what Nate's got to say later. He'll probably be on the YouTube here eventually on East Idaho News. Y'all make sure y'all go follow and all that good stuff, and you can catch his updates because I'm sure he'll put out something later this evening. I'd be surprised if he didn't, because I think he was planning on it. I haven't checked his Twitter in a hot minute. Let's do that before we head out of here, though. Everybody go get ready for their dinner and their evening and all that good stuff. Let's just check it out real quick. Let me get to Nate. Wait. Oh, Lord. Why'd they have to show me something on my feed that I really didn't care to see already? Wow. Okay, Nate's Twitter feed. Let's see. 1 hour ago, he just reported judges granted our motion and my name has been struck from the witness list in Lori's case. She said she wanted me as a witness. Okay, we heard what she said. He doesn't say anything about coming out here later, but I think he will. So Matthew Ballard was the attorney for the LDS Church. That's who we're talking about earlier when we were listening to that. So yeah, you guys can go check out Nate's Twitter. He's got a whole feed going on there from an hour ago of different things that we always watched it. So but if you want to check out his Twitter feed, because I'm always on Twitter checking things out, and it's a good place to go to. So he may be out here on the East Idaho News YouTube channel here in a little while. We'll see how that goes. Again, thank you everybody for coming back in and hanging out with me to watch the hearing. Yes, Rachel, exactly. From the very beginning, he was like the first one on the case, right? Chased her all the way down to Hawaii. You know she's big mad at him to start with. She's like, "That you're first on my list, Nate Eaton, my worst enemy." But I think she wanted to keep him out on purpose so he couldn't cover her case. That's all it was. But the judge made the right call. If a witness gets up there and contradicts themselves based on what they told Nate in an interview, then you can rely on the interview itself and not Nate having to get up there and testify to it. And that would pretty much authenticate itself because it was an actual interview done and memorialized, right? So that's kind of like self-authentication. We were just reading all about that stuff over there in the Cooper case, how you authenticate records and things of that nature. So I'm not worried at all. Yeah, he usually does his courtroom insider. If you guys, let me go grab East Idaho News link real quick so I can drop it for you guys who don't normally see them or any of that good stuff. I watch them a lot because, like I said, I've been following this case for years, following the Koberger case, so East Idaho News is always posting good stuff. I got their link and I'll drop it in chat for you. Go over there and sub up to these guys. They were, and that's where you can find everything Nate does. Yeah, like she said, he usually has his courtroom insider, and I enjoy that show. It's a good show to watch. He's got great insight. Did I miss something? You said, who is this? Who was we talking about, hun? What did I miss? Oh, Nate. Okay, got it. Thanks, Forrest. Can always count on Forrest for having my back when I get too busy and not paying attention to what's going on. Forrest is the man with the plan, and he's been my OG and my first ever mod. When I hit him up, I was like, dude, I need you to mod for me. He graciously accepted, and we appreciate you more than you know. You're welcome, Rachel. Just thanks for covering all this. I don't think I can handle it without you all. Thank you, Rachel. I appreciate that. And I enjoy having a community to watch it with. That's why I started streaming. I love talking true crime and watching all the things. And it's great to have a great community that wants to come in and do the same thing. We're not all here for gossip and the craziness on the YouTube streets. We're here about cases, right? So we'll be presenting a lot of different cases to you guys as time moves through. So I'm cutting my teeth on covering trials because I do plan to cover Koberger, as you've all heard me say. Lori will be that case we do that on. Thank God it's going to be on a 30-minute delay so I can kind of get my groove, and I'll be able to stop and run my mouth and not interfere with the actual live proceeding. So that's going to be a good thing. Karen Reed trial will be happening at the same time. So what I think I'm going to do is kind of like do recaps of Karen Reed, because I don't think I'll be able to stream both trials at the same time. I'm just not going to be able to do that, obviously. So I think I'm going to focus mostly on Lori's because I am more invested in that trial and the outcome because of all the other charges and trials I've already watched of Lori's. So I think that's where I'm going to go with it. And for all I know, a lot of you are interested in the Karen Reed stuff, so we will do follow-ups on that. We may end up doing 2 streams a day, the trial that day, and maybe come back and do a recap that night on whatever was happening in the Karen Reed case. So that we can keep up with both if we want to do it that way. If you guys have any suggestions, or this is our community. So if you guys ever have any suggestions, you can shoot me an email. You can drop a comment on one of the videos. I always check you guys' comments out, and I'm trying to get better at posting for you guys over on the community tabs in the channel, so make sure you keep an eye on that. And again, just thank you for being members, thank you for being subscribers, and just thank you for being here in general. I appreciate each and every one of you. You've really helped the channel grow, and I really wanted to cultivate a good community, and I feel like we are on the right path with that. So I'm going to let you guys go for the evening. I'll be back tomorrow morning. Usually I'm on between 9 and 10. So yeah, thanks for joining, and we'll be back in the morning at some point. I'll see you guys then. Have a great night.
Thank you all for watching this here video. Please like and